Hey, I'm Douglas Chandler.
I'm Britt Chandler.
And welcome to At the Bar with the Chandlers.
Thanks for being here.
So today we're going to be talking about professional liability a little bit.
Yeah.
Or maybe a lot.
Well, I just think a lot of people, even lawyers, don't understand what professional liability exposure really even means. So in the life of a Georgia lawyer day to day, what does that mean for them?
Yeah. What that means for a Georgia lawyer on a day-to-day basis is waiting for the shoe to drop, right? I think a lot of lawyers feel like they have a false sense of security about their firms, their processes, their procedures, and how things are being handled. Maybe not necessarily how they are specifically and personally handling things, but how their other people are handling things.
Right. That silent accumulation in their office that is festering and they don't even know about it.
They don't even know about it. And so when that shoe drops, it comes in the form of a claims notice letter or a love letter, as I like to call it, from some other lawyer that says you damaged your client and you did X, Y, and Z and you owe us money.
Right.
Or comes in the form of a bar complaint or a bar grievance, and from email in your inbox from the State Bar of Georgia saying someone has filed a complaint against you. And in Georgia, anyone can file a complaint or a grievance with the State Bar, and the State Bar can initiate its own grievances against members of the bar.
So those people that actually have the malpractice that they think that they're covered, what are some of the gaps that you've seen?
Well, first off, malpractice insurance is not required in the state of Georgia, but I believe it's a moral obligation to have it, and I think so we can sleep better at night, we need to have it. But in any event, there's gaps in coverage. So you go out and you buy a policy, and a lot of lawyers look for the bottom line cost. What's it going to cost me per year to have this policy? And then they don't even really look at what's covered and what's not covered. Sometimes, very important things, you don't have sufficient limits of coverage, right? So you have, for example, an average case value of $750,000, but you have a minimum policy limit of only $300,000. You are in an underinsured situation in that case.
Meaning that they owe the rest.
They owe
after
the gap,
yeah.
Right? Meaning they owe the gap. So if you have a claim that comes in for $750,000 and you have $300,000 in insurance, your carrier is going to pay $300,000. That's it. You're paying the balance of $450,000 out of your own pocket, and I've seen lawyers have to do that.
And what about those that don't have coverage at all?
They're paying the whole claim out of their pocket, and they're paying for their defense costs. That's another gap, is defense costs. Sometimes carriers pay defense costs outside of the coverage limit, which means if, let's say, you have a $750,000 policy in our example, they will pay a certain percentage up to and maybe in equal to that $750,000 in defense costs.
Wow.
However, the converse of that is sometimes the defense costs are covered within that $750,000. So for every dollar spent on defense costs, it erodes your coverage by $1. So in our example, we have $750,000 worth of coverage, but your defense costs to defend the case are $50,000. Well, now you only have $700,000 of coverage to cover a claim.
Right.
So that's a big gap.
Yeah.
Yeah.
Well, and you've been on both sides of the malpractice table, right? Because you've done the plaintiff, and now we're doing more of the defense.
Right.
So what has that brought you to being a better, educator for someone looking for this type of coverage?
Sitting on both sides of the table has given us, me, and the lawyers in our firm a much broader perspective on, number one, how to prosecute a case, number two, how to defend a case. We can anticipate the moves of the opponents and what those may be so that we can better handle our clients' matter for them. And it's also given us a perspective on how better to counsel our clients about avoiding problems, right? And that's what our firm is really about. Protection, avoidance of claims and grievances is really what we would prefer. That's the way we really want to help our clients. So sitting on both sides of the table gives us this unique perspective. And I would like to think it makes us wiser and better counselors for our clients, our lawyer clients at least. Yeah.
Well, and having come from a medical background and seeing the liability that's with the medical background and the gaps that are there, especially with risk management, and anything that ever untoward ever happens in any particular case or patient or visitor, we would always go back and look at what went wrong, how we could have made this better. And so I don't think people really understand the exposure of not being covered enough, right?
Right.
So, so what do law firms get wrong about their own risk management?
That's a great question. Ignoring it, quite frankly, ignoring it.
So how can they fix it?
Well, they can audit their firms themselves, right? Look into their own policies and procedures and get very honest with themselves about what is and what is not working. Or they can hire a firm to come in and audit them, or you can hire the state bar to audit you if you'd like to do that.
Oh,
too.
That'd be fun.
That'd be really fun. You can do that too. And the state bar does a pretty good job of helping with those sorts of things. But a lot of lawyers won't do that. And so you need someone who's objective to come in and audit your firm. We've done that in the past for clients. Remember one particular client firm had 5 offices, and they had 3 or 4 grievances over the course of about a year and a half. And it really, really bothered the owners of that firm. And they called me and they said, "Hey, we want you to come in and we want you to audit us from top to bottom." And I did. And
what'd you find?
Oh my gosh, they learned so many things. One of the biggest things they learned was that their paralegals were offering legal advice.
Oh,
it shocked the daylights out of them.
Yeah, I'm not a lawyer. I don't give advice.
Yeah, and that's a bad
thing.
Nor
does any of our non-lawyers in our office.
Yeah, so. It's highly illegal, obviously. So if you're a law firm owner and you're listening to this now and you're thinking, I don't know what my real exposure is, you need to have an honest conversation with yourself or with your partner. Or if you're a sizable firm and you have general counsel, have it with your general counsel. And if you don't, go outside your firm and get independent counsel to come in and take a look at your processes and procedures and figure out where your vulnerabilities are. By learning that, you can really prevent claims and grievances from happening.
And that's our dogs. And on that note, thank you so much for joining us. And please come back and join us at the bar with the Chandlers.
Goodbye.